There are two lists of exceptions to Rule 802's general bar on hearsay. Rule 803 lists types of hearsay statements that are considered reliable enough to be admitted regardless of whether the declarant is available to testify and regardless of whether she does. Statements allowed in under Rule 804, which applies only when the declarant is unavailable to testify in court, are considered less reliable than those allowed in under Rule 803, but better than nothing. Rule 807, the residual hearsay exception, provides a potential avenue for admitting reliable hearsay that is inadmissible under any enumerated exception. Rule 803 lists 23 exceptions to the general bar on hearsay evidence. About half of these require no explanation, at least for present purposes, beyond the text of the rule and its notes, which relate why each category of statements has traditionally been believed not to seriously implicate the risks of allowing hearsay. For example, we have already covered Rule 405, which explains that someone's character can be proven by testimony about his reputation. Rule 803.21 makes such reputation evidence, which of course is built entirely from out-of-court statements, admissible. Rule 803.22 makes a prior conviction, such as the one the prosecution wanted to introduce against Old Chief, admissible. Various exceptions apply to evidence regarding births, adoptions, deaths, marriages, divorces, and familial relationships. Several exceptions similarly relate to statements affecting an interest in land. 3 of these relate to documents traditionally deemed reliable enough to be admitted because of their age, because they comprise listings of information generally relied upon by the public, or because they are relevant to evaluating expert testimony. That leaves only a few unrestricted hearsay exceptions to consider. The Supreme Court's decision in Travelers Insurance v. Mosley introduces the first 3. The insurance company defendant refused to pay on an accidental life insurance policy, contending that Arthur Mosley died of natural causes. The question was whether Mosley's statements to his wife and his son, shortly before his death, that he hurt his head falling down the stairs, were admissible to prove that his death was accidental. As the court reasoned, evidence of what someone was thinking or feeling at the time of the events at issue in the case can be crucial. If it is not the only evidence on that point, it is often the best, explained Justice Noah Swain's opinion. The court noted that such statements are even more trustworthy when made to get medical treatment, which is reflected in Rule 803.4. That rule provides that statements made to get medical treatment or a diagnosis are admissible, regardless of whether they are made to a medical professional or anyone else. Reiterating that the justification for the rule was the need for such uniquely probative evidence, the court's opinion made clear, as does the current rule, that the exception does not apply to any statements conveying past events. The court, however, extended the doctrine to cover not only statements of the declarant's present thoughts or feelings, but also to cover statements about the cause of an accident or injury, so long as they were made at the time of the event, as well as statements relating to the consequences of the accident for as long as those lingered. These statements were grouped under the vague Latinism res geste, meaning things done, on the theory that Mosley's commenting to his family on his fall immediately after it happened was so natural as to make his comments part of the event of falling downstairs. Today, these holdings are echoed in the language of 803.1 and 803.2. In modern application, these exceptions differ in that 803.1 covers statements describing something just experienced, while 803.2 covers statements that more broadly relate to a startling event, something truly astonishing rather than merely surprising. Justice Nathan Clifford's dissent agreed that there was no other evidence in the case to show that Arthur Mosley's death was accidental rather than natural. Nonetheless, citing numerous cases, he argued that statements about past events were inadmissible, and he opposed enlarging the exception to cover statements about the cause of the declarant's pain. Rule 8033 still reflects Justice Clifford's understanding of the common law rule, including its prohibition on smuggling memories of past events or statements in under the exception. 23 years later, in another suit to recover on a life insurance policy, the Supreme Court applied Mosley to statements of intent. Justice Gray's unanimous opinion held that Frederick Walter's letters stating that he would be traveling west with John Hillmon were admissible to show his state of mind. In other words, his intention to go west with John Hillmon. The rule, however, is not as broad as the language of the case might suggest. In California v. Alcalde, the California Supreme Court admitted a murder victim's statement that she planned to go out with the accused, Frank Alcalde, on the night that she died. Justice Roger Traynor explained in his dissent that the statement should not have been admitted because its only relevance to the case was to show that Frank was with Bernice Curtis when she was killed. That was obvious from the fact that there was overwhelming evidence that Bernice had gone out, so her statement was not needed to show what she intended to do, but to show what someone else, Frank, intended to do. In each case, the declarant stated his or her own intention as well as someone else's. In each case, the whereabouts of one of those two people was undisputed, while the whereabouts of the other was material to the case. In Hillmon, it was the declarant's own intention that needed to be proven. In Alcalde, the statement was offered to show what the other person intended to do. As Justice Traynor correctly noted, for that purpose, the statement is hearsay. The hearsay exceptions derived from Mosley became divorced from their original purpose when codified. While they were deemed necessary to decide cases when the statements were material, particularly when the declarant was unavailable, the advisory committee believed that statements covered by these rules are reliable because the declarant has no opportunity for conscious reflection. That rationalization has made the rules susceptible to abuse. Fischer v. Texas illustrates. The case was heard in the Texas Court of Criminal Appeals, the court of last resort for criminal cases in Texas. After reciting the facts, the opinion hinted why the court decided to review the case. After losing on appeal, Texas sought review because the case concerned a practice in routine use. The court quoted John Fisher's argument that the recording introduced against him comprised only bolstering self-serving statements about what the trooper who stopped him for not wearing a seatbelt was allegedly saying and doing. It also heaped praise on Trooper Martinez. It noted that he began recording even before stopping Fischer to accurately record his investigation and that he spoke professionally and politely. But it also noted that he called Fischer the subject throughout. Despite going out of its way not to criticize the particular trooper involved in this case, the bare majority understood that the recording was completely unreliable. Having already noted that many similar cases had been prosecuted in Texas and that the officer started recording before, by his own account, he had any reason to suspect drunk driving, the court revealed its strong suspicion that Texas troopers were manufacturing evidence to frame people for drunk driving. The majority reached the correct result, as the history of the present sense impression exception in Texas shows. Houston Oxygen Company versus Davis involved a car accident between a Plymouth and a truck owned by the company. A 14-year-old passenger in the Plymouth was seriously injured. The company appealed the trial court's exclusion of a statement made by a passenger in another car. When the Plymouth passed that car, she remarked that it was traveling at an unsafe speed. Relying on several cases, including St. Louis, Brownsville, and Mexico Railway Company versus Watkins, the Davis opinion concluded, wrongly, that the statement should have been admitted, even though it was made 4 or 5 miles away from the accident site. There was no reason why the declarant could not have testified from memory. Watkins similarly involved a collision between a railroad car and an automobile. It stated the general rule regarding spontaneous utterances made very close in time and related to the cause of an accident. It further limited the rule to statements made by the person who was injured. Watkins relied on International and Great Northern Railroad Company versus Anderson. Echoing Justice Clifford's dissent in Mosley, the Anderson court restated the common law and noted that some cases, including principally Mosley, had extended the rule beyond its original limits. the court reluctantly applied Mosley's new rule. A dubious rule that was justified by the need to admit evidence crucial for allocating fault in accident cases, and that was adopted only reluctantly in Texas, came to be used by police to manufacture evidence against supposedly drunk drivers. Nothing in the rule's pedigree justifies admitting such evidence, and yet the attempt failed by only one judge's vote. This is the result of dumbing down the common law into broad, simplistic rules divorced from their true underlying purpose. Not surprisingly, the advisory committee's claimed reason for these exceptions has been criticized as irrational. In United States v. Boyce, for example, the Seventh Circuit considered whether Sarah Portis's statement to a 911 operator that her alleged assailant, Darnell Boyce, had a gun was admissible. Portis made the statement after running to a neighbor's house, asking to use the phone, being let in, calling for help, and being questioned by the operator. Unwilling to rule that the statement was made with enough immediacy to qualify as a present sense impression, the court instead relied on the excited utterance exception. Boyce argued that the statement was not an excited utterance because no one claimed the gun was involved in the alleged assault. The court, however, reasoned that Portis's knowledge that Boyce had a gun nearby meant that the gun was related to the assault. Judge Richard Posner's concurrence emphasized that the present sense impression and excited utterance exceptions have no rational foundation. In particular, the idea that people do not lie with nearly no time to reflect is preposterous. Judge Posner advocated a return to the common law method of deciding the admissibility of hearsay based on its reliability and its utility in the particular case at hand. Well before the 19th century, the common law made records kept in the ordinary course of business admissible when the witness who made the records became unavailable. Other records, however, were admissible only if the witness could no longer recall material information that he used to know. In Vicksburg and Meridian Railroad v. O'Brien, the Supreme Court held that a doctor's statement made in anticipation of a tort suit about the injured plaintiff's condition and prognosis was hearsay because the doctor's memory had not lapsed. The dissent believed the evidence should have been admitted anyway. The majority decision is codified at Rule 8035, which makes statements about an event the witness genuinely can no longer recall admissible. By the turn of the 20th century, American courts recognized that it was impractical to require all the witnesses who contributed information to business records to testify in court. Rather than making a series of witnesses appear to establish each transaction, routine business records became admissible. By 1943, a federal statute codified the exception, which made admissible, as Rule 8036 does today, all sorts of records that businesses routinely rely upon to make decisions. Palmer v. Hoffman held that the exception did not, however, cover an investigatory report made by a railroad company after one of its trains struck the plaintiff's car, killing his wife and seriously injuring him on Christmas Day 1940. Echoing the O'Brien case, Justice Douglas's unanimous opinion held that such reports are unreliable because they are made in anticipation of litigation. A corporation's self-serving investigatory report is not the sort of business record the exception contemplates. The types of records that are deemed reliable and thus admissible are those that the company itself relies upon in running its business, not those created for another purpose, especially when that other purpose is litigation. Nichols v. Webb extended the rule admitting records made in the routine course of business when the declarant is unavailable to records made by a public officer pursuant to his duties. Justice William Brennan's opinion for the court in Beech Aircraft v. Rainey resolved a circuit split by holding that official reports by public officers are admissible even when they draw conclusions from the facts they recite. The court noted that such reports are admissible only when nothing about the circumstances of their creation calls their trustworthiness into doubt. Trustworthiness does not depend on the substance of the report, but on how it was made. For example, a report is untrustworthy if it was made by an unqualified person or if it was influenced by bias. The exception for business records contains the same requirement of trustworthiness as the exception for public records and reports. Rule 8038 makes clear that law enforcement or investigatory reports are not admissible against a criminal defendant, and such reports are generally testimonial because they are made with a view to prosecution. In Melendez-Diaz v. Massachusetts, the Supreme Court considered whether reports of laboratory tests commissioned by police for use in a prosecution are testimonial. In a straightforward application of Crawford, a bare majority of the court held that they are. After refuting the suggestion that there is any such thing as a neutral witness for the prosecution, the majority reaffirmed Palmer's holding that records made with a view to litigation are not reliable the way ordinary business and public records are. The court made clear, however, that even if the analyst's records used against Melendez-Diaz did qualify as business or public records under the rules of evidence, they would be testimonial and therefore inadmissible without confrontation because they were made for use at trial. Justice Kennedy's dissent argued that the Confrontation Clause should make allowances for prosecutorial inconvenience in drug prosecutions, similar to the way the common law made allowances for business records. The difference, of course, is that the Sixth Amendment's purpose is to make prosecutions more difficult and thus more fair. To get around that, the dissent hung its hat on the absurd idea that laboratory analysts are not witnesses against the defendant. The dissent is nothing more than a weak policy argument for the repeal of the Confrontation Clause in certain cases.